Well, that was something. In the prosecution's closing arguments in the Jordan Lamonde case, we on the network for the first time have a clear view of this video that was taken of the beating that serves as the basis for this criminal action against Jordan Lamonde. I'm joined here with Jill Stanley. Jill, you're a trial attorney. Let's talk about this video and what this means to the jury. Now, it was shown during the course of the case. We now have seen it clearly for the first time on the Law and Crime Network. But is this going to sink the ship for the defense? That looked pretty brutal.
This is the piece of evidence every prosecutor wants. This is going to sink the ship in some ways for the defense, because it really shows the brutality of this assault. And remember, this is a felony charge. We are not dealing with a simple assault here. This is a felony charge. It is serious stuff. But the whole gist of this case is the defense feels that the defendant, Lamonde, was charged incorrectly simply because Aaron, the victim, did not suffer serious injury. But when you look at this video, you watch this pummeling. Actually, you watch the premeditation of it. You watch this man leave his car. You watch him go in front of his car, drop his water bottle, see this woman from the back attack her. This is what we're seeing here. So we see a man coming after a younger woman, attack her from the back, and pummel her 40 times. There is no one who sees this video and thinks this man has regard for human life. And that's the law in New Hampshire. That is why he was charged with a felony, because he showed extreme disregard for human life.
Jill, that is such a great point, and something that we want to break down for our viewers, because obviously the jury had seen this video. Now, we didn't have a great angle in the courtroom when it was played, so we're seeing it for the first time. And what's out there in the media is only a snippet of what we see in the courtroom today, what we're seeing here on Law and Crime. But this case really turns on that language. Extreme indifference to the value of human life. So what do you make of that? Do you think the prosecution has proven that beyond a reasonable doubt?
I think they have. Let me clarify that, actually. I think they have. Does that mean the jury is going to believe they've proved it beyond a reasonable doubt? There is kind of a little question. Well, she really wasn't injured. And in fact, she did remarkably well after this assault. There's a lot of footage of her after the assault, and she really just was bruised and tough and emotionally tough about it, too. However, we all know that the damage from an assault like this is very long-lasting and isn't just physical. So when we think about this, really what we have to look at, it's the law here. This isn't just about the physical injury. It is the letter of the law. The New Hampshire prosecutors, when they drafted this complaint and knew what to charge this defendant with, looked at the kind of level of the assault. This is 40 hits, 39 to 40 hits. That is brutal. But then he left her there. Now, she did get up and ran to her car with fear of being run over.
Right.
This is indifference to human life.
Jill, those are all great points. And what we saw the defense focus on was the fact that she wasn't terribly injured. But does that matter? More with Jill Stanley after this. But right now, we're going to a break. So we're in verdict watch in the Lamonde case. We were watching the closing arguments of the defense and prosecution earlier today. Our own Aaron Keller from Law and Crime is in the courtroom. We won't miss a beat if that verdict comes down today. But right now we've been watching the Kirkland case. This is, of course, the man who killed 5 people, a resentencing hearing now. I have Jill Stanley here. You're a trial lawyer, Jill. Let's talk a little bit about what happened at the original sentencing part of the trial and why we're even here in the courtroom today assessing whether or not the death penalty was appropriate.
So in the original trial back in 2010, we know that Kirkland pleaded guilty to 2 murders, and then he was tried for 2 other murders. The jury found him guilty of those aggravated murders and sentenced him to death. The judge approved that. He was on death row. He appealed that. And it's a right of appeal we have. It's a very immediate right of appeal in the United States. And it's a good thing. The death penalty is very serious. And as you may know, only 31 states in the United States still have the death penalty. Ohio being one of them. And in fact, Ohio just executed someone just last month. So they use their death penalty. And so we can understand Kirkland and his team's concern about this death penalty sentence. So there were allegations that there were prosecutorial misconduct in that first trial. So I know that sounds like a really bad term. Ooh, the prosecutor's so bad, must have been hiding something. That's not actually what happened here. What happened here is we have a very experienced prosecutor, by the way, very, very experienced lawyer who tried this case. And in his closing, he was passionate. He was dramatic. But don't forget, we have a 13-year-old girl and a 14-year-old girl raped, murdered, burned. So you can understand the passion that this man is feeling about this case. This is not a shoplifting case. And so he had a lot of passion for it. And he did speak zealously in the closing. And in one part of his closing back in 2010, he said, if you don't give this guy the death penalty, it's a freebie. And what did he mean by that? Well, he already had a life sentence for the other two murders. So if now he gets life sentence for these two young women, then really what is his penalty? And that was what he said to the jury. And unfortunately, that term was a little too inflammatory, a little too outside of the bounds of what a prosecutor can say. And so when he said, if you don't give him the death penalty, it's a freebie, defense did not like that. And so that was the crux of the appeal. There were also some other issues which really go to the legal matter of when a jury decides to give a death penalty as a sentence, they have to look at the aggravating causes of the murder, specification is actually the term, versus the mitigating factors. In this case, the aggravating factors, which by the way have to be pled right in the indictment, you know them at the beginning, they're not surprises. We know it the whole trial, we're talking about it. So it's, in this case, it was murder with a rape and an attempted rape, because we were able to prove the rape beyond a reasonable doubt in the first trial of Esme, and then the attempted rape of Asanya, who was the second victim in that trial. And then there's also this third specification of course of conduct. So it's a little complex legally, but basically the prosecution had to plead this. He murdered them, and there was rape, and there was an attempted rape, and there was a course of conduct because this guy's a serial killer. So those are the aggravating factors.
Right.
Then how do we fight that? We fight that with mitigating factors. So yes, he killed these people. But here's why. Because he's mentally ill, because he was abused, because he was a drug addict. He did express remorse. He did give a confession. He did lead the police to Esme's body. So all these things, we have to look at them and say, does this mitigate the sentence of death? And that is really what we're looking at here. So prosecutor did go outside the bounds a little bit. There's a lot of leeway. So this was not a very clear-cut decision.
And it's a difficult hurdle to have a new sentencing hearing.
Yes.
From an appellate standpoint, appeals can be very, very hard.
Yeah, we're 8 years.
To be successful.
We're 8 years later. This verdict came in 2010. He was granted the right of a new sentence in 2016. We're in 2018 having this trial. We have a whole new jury that had to be picked.
Right.
This is a lot of resources, a lot of time, a lot of money.
And now we see where we are right now. So we're in the sentencing phase, and we're seeing a lot of expert testimony, and that's what the defense is really hitching their wagon to. And of course that comes down to the old battle of the experts. So what does that mean? Where will the jury fall? We're not sure yet, but we will continue to be live in the Kirkland courtroom as we continue to hear more witnesses. Right now, we have the video deposition of Dr. Daniel Butler. This was the prosecution's rebuttal witness. He's a radiologist. He seems to be testifying with respect to the brain abnormalities that the defense has indicated are a mitigating factor in this case. So we're going to continue to see this expert testimony and these experts on the stand. Jill, do you lose a jury with this amount of expert testimony?
It is hard for a jury to pay attention to this kind of deep medical testimony, and that's in any case, really, whether it's a murder case or just a car accident case. It's a little dense. It's not as exciting as visiting the crime scene, which this jury did, by the way. They visited the crime scene. This second jury doing the sentencing went again to the crime scene to see where this little girl's body was laying. So is it as exciting and as easy to pay attention to as that? No, it's not. But this jury knows what their job is. They know and have been, and will ultimately be very instructed on this, but they know what their job is. They need to figure out what is the proper sentence, and the only way that they can do that is to understand the aggravating circumstances and the mitigating circumstances. So this medical testimony, as you said, speaks directly to the mitigation.
Absolutely. And from the prosecutorial perspective, there's been a lot of focus on the brutality these murders, and of course that is something that's going to be very effective with the jury, but we don't know where this case is going to land. We're going to go back live to the courtroom now for more from Dr. Daniel Butler. We are live in the Kirkland trial. We're watching some expert testimony, a prosecution rebuttal witness. This is a deposition from earlier this year that is now being used in this sentencing phase of the trial by the prosecution. We are also on verdict watch in the Jordan Lamonde case to catch everybody up, to catch the viewers up. He is facing trial after a viral video allegedly showed him beating up a female employee in a parking lot of a Planet Fitness gym. Jill Stanley, I want to talk to you about this. You're a trial lawyer. First and foremost, this is an interesting story because it's a viral video that really brought this guy into the courtroom.
A viral video, not about a cat. So it's nice to have a viral video that actually is serving justice. And it really did here. So what happened was the footage was released. It was viral. Everyone saw it. A woman by the name of Savannah, who knew Lamonde, said, wait a second, I know this guy. And she went on Facebook and she saw, and they couldn't connect the victim and this defendant yet, but she went on Facebook, Savannah, after she saw this video and made a connection between the victim, Aaron, and her boyfriend, and a friend, and the boyfriend's brother, actually. It's unclear whether it was her boyfriend or the boyfriend's friend, but the last name Bunch
so we
was
have
the same.
A connection between this woman in the parking lot and the defendant.
All through Facebook, because she was looking at the friends. You know, you can see who people are friends with. She went on, she said, hey, that looks like Lamonde. Saw Lamonde, had a similar friend as this person's last name Bunch, then connected it to Aaron, and it went all around. And that is how the cops figured out the guy in the video was Lamonde. And so we kind of talk socially frequently about how bad social media is and how people videotape terrible things and then they go viral, and we're all kind of focused on this kind of devastating effect of social media. But let's give it its due as it is owed here. This actually wrapped up this case. We found a defendant because of Facebook. And also Aaron, very interesting. Aaron is the victim in this case. The defendant's sunglasses fell off during the altercation, during the assault, and she picked them up and she put a photograph of them on her Facebook page as well. Wow. So people were really using social media to serve justice. And I really like when that happens because it's very easy to talk negatively about social media. There is a lot of bad to it, no doubt. But here, when it's good, we have to give it its due.
Yeah, and we know that now a lot of crimes are caught on tape and they're distributed, as you said, via Facebook, social media. It's really changing the game of trial practice, of the way investigations are conducted. Everything from the Fitbit to the Alexa, we've seen this stuff in evidence of trials. So when you have a video like this, which, by the way, we saw in detail for the first time here on Law and Crime what the jury saw.
Yes.
This video of this beating.
The entire assault is visible to the jury. This is very uncontrovertible evidence. This is, as I said, this is the piece of evidence every prosecutor wants.
Absolutely, yes, and the jury sees that, and it's no longer a description of what happened to this person. It's right there, video to the jury. So let's shift back to Kirkland. We are going to be going live into the courtroom. Of course, the aggravating, mitigating factors, that's what this case hinges on, right?
Right, that's what we are looking at here, and this is such a complicated case. At first blush, it seems pretty simple, right? We have dead girls, we have a guy who confessed. So we're not talking about, did he kill them? That's what I want to be really clear with. We know he killed them. He confessed. That is not an issue. The only thing we're talking about here is life in prison or death sentence.
Right, and that's a great clarification because he's guilty. I mean, that guilty verdict did not go away. The guilty verdict stands. This is just about the sentencing phase of the trial after an appeal. So now we do have to go to a brief break, but don't go anywhere. We're going to be back live in the Kirkland courtroom in a few minutes. Welcome back to the Law and Crime Network. I'm Misty Marris. We're here live in the Kirkland courtroom. We're also on verdict watch in the Jordan Lamonde case. But right now we're still hearing some expert testimony in Kirkland, so we're going to focus on that trial right now. I still have Jill Stanley here in the studio. You're a trial lawyer. You teach trial skills as a professor. So tell me, take out your crystal ball for me. What do you think is going to happen in the Kirkland case? We have a serial killer. We have a guilty verdict. Where's this case going?
So if I were a betting person, without hearing all of the full testimony from all of the experts, because although it is dense, and we spoke about that a little bit, it is a dense bit of information that these experts are testifying to. But this is the crux of the case. Do what the experts have to say, do they really mitigate the aggravating factors in this case? Does it mitigate that there was rape? Does it mitigate that it was attempted rape? Does it mitigate that there was a course of conduct, that he was in fact a serial killer? So that is all it comes down to. So without hearing the full testimony of all these witnesses, I'm going to say, with my crystal ball that you're allowing me to read from right now, I would be surprised if this jury did not return a similar verdict as they did in 2010. Sentencing verdict with the death penalty for Anthony Kirkland.
You know, I have to agree with you, because even watching some of the expert testimony, and we saw earlier today one of the defense experts really being torn apart on the stand because he's a litigation guy. So there's a lot out there. Why don't you talk a little bit about that? When you have a doctor who's been on the record so frequently, what does that mean?
Well, in this case, we had two doctors who have been on the record against each other several times.
So they know what they're up against, I guess, right?
And I think in some way it dissipates the kind of bias, if you will, to have a paid witness. A lot of times juries will think, well, this guy was paid to say that for the prosecutor. Well, they're both paid, basically, to say that in some sense. So we really have to drill down to what are the qualifications of these experts and who is more credible. Who do we believe? Because they're both paid.
Right.
So that is how it goes. And the jury knows that. And the jury knows that these two have been against each other before. But it's, where is the information landing with this jury? Now, the fact is, in most murder cases, we are not dealing with a perfectly sane person. It's a murder case. We have a man who pled guilty to murdering 4 women and has already done jail time, prison, 16 years for murdering someone else. So does anyone on this jury actually think we're dealing with a 100% sane person? Of course not. So then we have to really look at, did his childhood mean anything in the mitigation? Does he really have brain damage? What did the drugs do to him? What is the power of his remorse? What is the power of his unsworn statement that he gave in the last trial and will likely give again in this one, saying basically, I'm sorry.
Right. And Jill, I want to focus on that because that's it's an unsworn statement.
Yes.
He's able to make this statement, and the purpose of that statement is really to say he's sorry, and that hopefully the jury believes that he's truly remorseful. How far does that go in a case like this where you've got such terribly horrific facts?
Well, let me do my independent view of it. It didn't go far with me, not one bit. I didn't feel the remorse.
And we're going to be seeing that again. At least that's what we anticipate. So.
And when you hear the gruesome details, the aggravating factors, the attempted rape, the rape of a 13-year-old girl, the burning of bodies, that would have to be the most beautiful piece of sorrow and remorse to actually convince sane, rational, thinking people to think that was okay. So, yeah, it's nice that he says he's sorry, but this is not a shoplifting case.
Right.
This is a murder case, an aggravated murder case with 2 young victims, with a guy who's already serving life in prison for killing 2 other people.
Yeah, I mean, we're talking about a serial killer here, right? And that's not lost on the jury also. We know he pled guilty to 2 murders of women prior to his actual trial in this case, where he's found guilty of the murder of a 13 and a 14-year-old girl.
This is a man who engaged in a course of conduct. We're not dealing with he had a fight with his wife, was mad at her because she cheated on him and shot her. This is not that.
Right.
This is a course of conduct, a way of life for Anthony Kirkland.
So let's talk a little bit about the fact that the defense is also focused among, the abnormalities in the brain, some of the medical diagnosis of mental illness. Let's touch on the alleged abuse from his childhood and the impact that had on shaping him. Is that going to be a solid argument? Because we see that come up in a lot of sentencing phase of the trial. That is a common theme that we do see, because it is many of the people sitting on that stand found guilty of murder have had something in their past that
no doubt
may have contributed.
No doubt, and it's tragic, and it did ruin his life. It did alter the way he approaches human relationships. There's no doubt about that. And there's probably no one on that jury who doesn't have a little sympathy for that.
Right.
But there are millions of people who were abused as a child who do not go on to become serial murderers.
And that is what we're going to hear the prosecution say in this case. Jill Stanley, thank you so much for joining me today. I want everybody to go to Jill's website, Proof with Jill Stanley. Check out her commentary on the top stories of the day. Thank you so much, Jill. I hope you come back soon. So right now, Kirkland, it is wrapped up for the day. So we will be reviewing some of today's testimony and looking back as we wait to see what's going to happen next in the Kirkland case. We are also on verdict watch in the Lamonde case. We have our own Aaron Keller in the courtroom who will let us know if there's any activity. In the meantime, while we wait to review some of what we've seen today, let's go to today's top crime stories. Take a look.